When there is non-compliance with the formal requirements, naturally, a will be set aside. Then, of course, in cases where a custom protects assets or persons, the court may look into it. In some regions, especially under customary law or Sharia law, a testator cannot validly disinherit children or spouses without providing for them. Let me explain a little bit. Under Sharia law, there are specific quantum of your assets that you have to give to your family members. If you disinherit them, they may go back to Sharia law, make resort to Sharia law, and Sharia courts may look into what you did and ask if you were truly a Muslim. I mentioned public policy just a while ago. So in some cases, the court looks at whether what you did was reasonable or whether it was against public policy. In a certain case, the court had to invoke this public policy to invalidate a will that completely excluded the natural legal dependents. We'll talk about one or two of such cases down the line. But also, there are cases in such regions as we know in Nigeria where customary law is applicable, or where the testamentary disposition was incomplete. The duty to provide for family members may override those choices that you've made. If, for instance, the family property was involved, then the court will look at it. If you occupy a family property originally belonging to your forebears, and by reason of you being the first son, you make a will purporting to give that same property to your second wife or her son, who is your last child, the court will look at it and find a balance between testamentary freedom and legal responsibility.